Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Cison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cison.
Hi, everybody, and welcome to the October 2022 edition of the Third Fridays podcast. My name is Christian Cison, back with you guys again, and we had a very eventful show last month. We had two guests, Addison O'Donnell and Christopher Major, talking about an appellate division case that came out earlier this year that involved a lot of risk transfer issues and a claimant who wanted his workers' compensation claim to be disallowed. So if anybody wants to tune in to that episode, it's definitely still available. It's actually one of our highest listened to episodes of the year. But we have something different for you today. Today we're going to talk about the new Onboard and prior authorization request system that debuted in New York workers' compensation earlier this year. I believe it started in May of this year, and we've now had about 5 months to see how it's being worked through the process at the court level and with employers that we represent. So for that purpose, I have invited Noah Pollack, Senior Associate from Lois Law Firm, to the show. Welcome, Noah.
Thank you, Christian. Very glad to be here.
Yeah, Noah, I guess before we get into that, when I was announcing last month's podcast, I saw your reaction to this fact pattern where, a claimant wants his claim disallowed. So just to briefly go into it, and we won't spend the entire podcast talking about last month's podcast, but this person was shot as a resident physician in a hospital when a former doctor at that hospital who resigned because he was accused of sexual harassment put his lab coat on, walked through security in the hospital, and shot up the place. Wow. And the claimant was, this resident physician who wanted his workers' compensation claim disallowed so he could get rid of the exclusivity provision and get more money in civil court. So it was this weird case where the hospital's carrier was going into court. They filed an RFA2 to get a hearing just to establish the claim, to have the exclusivity provision in place and break the claimant's ability to sue the employer for, 8-9 figures in civil court. Isn't that crazy?
It's interesting. I mean, honestly, just thinking about it from a comp perspective, from a carrier perspective, there would be a good argument just to disallow the claim. And the claimant could argue to disallow the claim. It's not being work-related within the scope of the employment. I mean, doctor going in there, an ex-doctor is not even working there, going in there, shooting up the place. I mean, it's tragic. It's crazy. I mean, I hope that the only injuries suffered are active comp claims, not death claims. But doesn't seem to be within the course and scope of employment. I could see a carrier rushing to accept that claim to ensure that massive exposure lawsuits are not filed.
Right. So the board panel agreed with the carrier that they had the right to accept the claim, and the claimant appealed to the appellate division, and the appellate division overturned it. So they disallowed it because they believed the claimant's position that it wasn't within the course and scope of employment. But, reasonable minds can disagree that a disgraced former employee who has resigned for sexual harassment allegations coming back wearing the same lab coat, I don't know, maybe that's work related. But you'd have this weird situation where a claimant is saying that this is not connected to work. Loads of fun. And I'm putting that in quotes because I feel like only people like you and me would think that's fun. But let's get on to today's topic. To all our listeners, I invited Noah mostly because he's been a very good resource for people in our firm as it relates to, medicals being the high cost driver of workers' compensation claim. Noah's been a very big proponent of articulating how indemnity, even though it can be very expensive, is sometimes indemnity is so tragically forgotten when it comes to high cost drivers of medical. So like, no, like even before Onboard started, what led you to feel like that was the message you wanted to get across to people in our firm?
Well, it's generally because when you think about workers' compensation defense, what we do at hearings, actions that attorneys take on behalf of employers and carriers, we really do on the surface just think about cutting awards, reducing awards, suspension, fraud, which only impacts awards. So you really just think about it in terms of, okay, how can I reduce the indemnity exposure? I don't want the claimant getting paid. Because also the average person thinks about workers' compensation. They think, okay, someone's not working, they're getting paid. They're getting lost wage indemnity benefits. And so it is forgotten, the element of workers' comp, which is actually more than half the exposure when it comes down to it, is the medical component. And it's important to think about that because it really will set you apart as an attorney defending an employer carrier if you can cut into the medical exposure and the medical cost, because they are more expensive. I mean, because workers' compensation, these claims are open, claimants are working and not getting paid, but they're getting medical treatment. Or if you just think about the cost of surgeries, fusion surgery, knee replacements, $25,000, $50,000, $100,000, which easily eclipse, schedule loss of use awards. And beyond that, I think it's very important to think about workers' compensation claims. I mean, I do because of the work I do on the construction practice group, that a lot of workers' compensation claims will have a general liability action attached to the accident. I mean, you're actually talking about, it's interesting because you were talking about that claim last week for an ex-doctor shooting up the workplace, and the exclusivity clause that the carrier wanted it established as a comp claim because then they wouldn't be allowed to sue, the claimant wouldn't be allowed to sue the employer in court. But a lot of construction claims, because they involve general contractors or owners, they're not actually suing the employers, they're suing the general contractor or the project manager or operator. And so they have it, but the money is coming out of basically the same entity. And so because of that, I know if you can do verdict searches for how much certain surgeries are worth. And I can tell you that a lumbar or cervical fusion surgery verdict value is over $1 million.
Wow.
And you're going to be very hard-pressed to find any compensation claim where over $1 million, even near $1 million, is paid out in indemnity. So, again, it's about being the best attorney you can be, and it sets you apart if you're able to cut into the medical exposure.
Yeah, even a lot of permanent total disability cases don't reach $1 million in indemnity, so, and that's the worst thing we can get. So it's a great point. I think, especially with your experience in the construction industry, knowing that if you can get a cervical fusion that lifts the value of your general liability claim, it also helps to get it established on the compensation claim because it's a quicker route. It's a quicker route to get somebody held responsible, and then you connect the accidents. I was also thinking too about how, indemnity is very cut and dry. Like, you're out of work, or I guess it's supposed to, right? You're out of work, and whether your wage loss is related to that accident. But medical, you can go to the doctor as much as you want, whether or not you're out of work. And then within those medical reports, our clients face this all the time, right? Where there's just so many diagnosis codes that have a separate fee schedule bill, and then that gets racked up. And you're right, like most workers' compensation attorneys don't think about that medical costs because they believe it's just being handled by the adjusters in-house.
That's true, 100%. They think about it more as a clerical or administrative type issue, dealing with the medical bills, denying medical bills, and really there's substantive issues. And I think a lot more lawyering is involved in the medical because you're evaluating medical evidence, you're doing the depositions, and you're really getting into more nitty-gritty medical issues. It's difficult as a lawyer to get into it with a doctor on substantive medical issues, but it really is a test of your abilities if you can when you're attacking the medical components of claims.
So when we look at Onboard, right, before Onboard started, there was just the regular variance process and authorization request process. You led a training for our firm last year, around this time last year, and you talked about the medical treatment guidelines and the variance process being an advantage for employers, right? We can use the guidelines almost to deny variance requests by proving, for instance, that the provider didn't meet the burden of proof, right? We don't need an IME all the time to deny a surgery. Has that thought process changed with respect to Onboard? Do you still feel, I guess, well, before we get into that, what is Onboard and the prior authorization request process that started in May compared to what it was in April and before that with the variance process?
Right. So essentially what the onboarding and the prior authorization process is, it's moving medical treatment requests from paper to electronic. Basically, all MG2s and C4Os primarily are being replaced by the onboarding PAR system. So whereas before, healthcare providers would have to email or fax, requests for treatment, certain requests for treatment. Now everything is done through the board's Onboard online system instantaneously. So you have the healthcare providers involved, and you have the payers, the insurers involved. So it basically takes everything from paper to electronic. I did see that the board said one of the benefits, the great benefits of the onboarding system is they're saving 850,000 pieces of paper. So they said.
Okay. Yeah, I guess
we're helping the environment with the onboarding.
Yeah.
But that's what it's moving from paper to online, all of the almost all of the treatment requests.
So, there are there is this movement, right? You're right. I mean, it is making it more electronic friendly. And what have you seen, I guess, to be the carrier or employer response to the deployment of this system, at least in the early going? Like 5 months ago, this happens. Like, did employers and carriers love that we were going to save 850,000 sheets of paper, or were they upset about this development?
Well, I think there's really two parts to that. One is the administrative change, and the second is substantively. So first, whenever you're changing a system that has been so entrenched, the MG2, the variants, and the C4 auth request, the paper, email, fax system was in place for many, many years. And so the carriers, had their routine. They set up their protocol, the logistics for handling that, and they will deal with them accordingly. Now, the onboarding system really upended that. You had an entrenched system that was upended, and they're putting something new in. So anytime you're putting something new in, especially this tremendous scope, you're dealing with just a tremendous amount of requests coming in every day, and it's instantaneous. Whenever you're dealing with that kind of change, there's going to be growing pains. So I think just the change itself, and we're only 5 months into the last phase 3 rollout of the system. There's a lot of issues with carriers setting up the system, the protocol for handling onboarding. They had to go through a very quick training. They had to set up their basically they have a separate, most carriers will have a separate team or department that's dealing with it. So just the changes alone, structural changes alone, will lead to things falling through the cracks and not being able to handle the new load that's coming in. So that's number one, and we're going to see. I think that may ease as the months go on and everyone becomes more comfortable with the system. But that's the number one issue right now. Substantively, I did feel that the paper and email, the slower system of the prior MG2 and C4 auth requests, I did think that benefited carriers, if only because it allowed more opportunity for, I think it made litigation easier for carriers when they would just simply deny an MG2 or a C4 auth and would immediately go to a hearing, and then you could litigate accordingly. You want to take depositions of doctors. It allowed that. It allowed us to do more. With this system, because the way it's set up, it's more difficult to get that type of litigation. When just looking, I would advise everybody to go through the board's resources and training. They have, it doesn't take that much time. You go through it all to familiarize yourself with it. But the way the system is set up and how reviews are generated automatically, what the carriers need to do, and then how reviews are then sent to a medical director's office for final resolution, things of that sort. It takes some of the litigation opportunities away from carriers and from and from attorneys. I think that's substantively the most difficult aspect of it. But overall, I think as everyone becomes more comfortable with it, it shouldn't be that different from how we were addressing treatment requests before. That we will be able to contest the way we would normally contest treatment.
That's a great point, actually. Just even without considering the substantive, development of how we respond to a new system, the fact that it's a new system itself, right? You mentioned that it's going to cause some things to fall in the cracks just because people have to change, how they react, when they react, what systems they have to put in place. I didn't actually think of that, right? Like just the idea that we're changing something is going to make it harder for the stakeholders involved. Great point. And then when you go to, the quickness of the resolutions, right? Yeah. I don't know if you experience this in your cases, but what I've seen sometimes in my group is that you have a couple of different problems. One, you have a team being set up, like you mentioned, right? Because the adjusters aren't going to be able to handle all the PARs immediately, right? So they have this setup team. It might be a utilization review. It might be another person within the carrier or the TPA's company who just addresses this. And then when they address, a request for surgery, they don't realize, for example, that authorizing that surgery, even if it may be medically necessary, might be waiving your defense of causal relationship as an advance payment of compensation. So I've seen that type of issue. I've also seen even a more benign sounding issue where, we have clients, for example, that say, no, this person does need surgery and it is our responsibility. We want to pay for it. But because the onboard system maybe initially went through a level 1 denial because maybe there was something lost in translation, the provider, instead of knowing what to do and making that level 2 request, they just assume it was denied, or maybe they file an MG2 because they think it onboard, messed up. And now the whole process keeps moving along without resolution of that surgery. Do you see any of those two issues happen in your cases?
Well, I will say the worst problems I find, and it probably has to do with the fact that, like you were saying, like I was saying before, the carriers, the payers have set up a totally different apparatus or somewhat separate apparatus than the day-to-day handling of the claims by the adjusters. So the ones handling the PAR reviews in onboarding operate somewhat independently of the adjusters, even though level 1 reviews can be done by anybody. And I would strongly advocate that adjusters are the ones doing it. Absolutely. Close contact with them. Often that is not the case. And because of the divide between who is looking at these requests and the adjusters and the ones handling the claims day to day, some of the defenses can be lost, like you were saying, causal relationship, or they don't know what's going on in the case. And so sometimes they'll just look at the request and the treating provider's reports and take them at face value and say, oh, okay, yeah, the guidelines are met, the site is established, so yeah, let's authorize. And that just doesn't happen with level 1. That will happen with level 2 reviews as well. And I find often you need to be so on top of your claims and making sure the adjuster is letting everyone know, by the way, if this treatment request comes in, we have this defense, this defense, this defense. It can't just be about medical necessity. I think causal relationship defenses, when sites are established, I mean, this is probably the biggest issue I have with medical treatment on comp claims generally, is that once a site is established, it's treated as if all treatment for that site is going to be related to the claim no matter what. It's kind of like you stub your toe 5 years ago, and now you want, I don't know, some toe surgery, a fusion, whatever it is. Something like you twist your ankle, 5 years later you want an ankle fusion, or you picked something up and you threw your back out, and now 10 years later, and you had a comp claim, and now 10 years later you want fusion surgery and it's related to that. And so those causal relationship defenses, there's really no place for that kind of defense. There's a place for the compensability threshold. There's no causal relationship for the site of injury to begin with. But the causal relationship where the site is established, we're saying, well, the knee might be established, but the knee replacement surgery is not related. There's really no place for that in the level 1 and level 2 responses, unless you tell the doctor responding level 2 they're really aware of it. So now actually very important to let carriers know and for attorneys to know, the RFA2, there's a new RFA2 that was instituted with the phase-in of the onboarding system. And there's actually an item in an RFA2 where a carrier can contest future medical treatment on causal relationship grounds and provide a basis for that. So if that's filed, if you have that in a file, that's something important. That's a tool to use to defend against these claims where there's no dispute. You have many claims. I'm sure you have many claims. I have many claims. Where there's no dispute that a claimant has bone-on-bone osteoarthritis in the knees. No dispute that a knee replacement is medically necessary. The dispute comes down to whether it's related to that accident you had where you twisted your knee 5 years ago. And in that case, you file once you have an inkling, any sort of hint that there's going to be a knee replacement requested or some sort of surgery or some extensive treatment, make sure the carrier knows there's this option of filing the RFA2. And that is protective. I actually think that the board put that in there because they acknowledged the deficiencies in dealing with the causal relationship question on sites that are already established.
You're saying that the board is giving us a chance here? That's interesting.
They put that in there. And beyond that, it's important to know also that the new RFA for carriers, you can contest an MDO level 3. So level 3 reviews are all done by the board, the medical director's office. The carriers are doing level 1s. Anybody can do those. And then a denial in part or granting in part will automatically take it to a level 2, which has to be done by a doctor for the carrier. And I will say that increases costs for the carrier because you have all these automatic doctor reviews, whereas before you could have had a registered nurse practitioner, some other provider. Now you have to pay a doctor for many of these level 2 reviews that are automatically that are mandated and they're generated automatically. But level 3 reviews for special services, which were the C4 special, the most expensive types of treatment, fusion surgeries, TKRs, things like that, as well as variance requests. Those you can actually still file an RFA2 to request review and get a hearing. So it's not like once you have that level 3 resolves in favor of the provider, that's the end of the deal. They still allow that litigation, but it's about familiarizing yourself with it because I haven't seen carriers are completely blind. I haven't seen any case that I've had that carriers, at least on their own terms, before we give them any advice, are filing those.
Yeah, I think you said 3 really interesting things there, and there's so much content. There's so much content in that last little soliloquy that you had that I was actively trying to remember all of them so I could flesh them out. The first thing you said was totally on point, right? Level 1 reviews by the adjuster, because it actually envelops the problem that we were just talking about, where if a treatment request comes in and we're not on top of it because there's so many of them and so many cases on the docket, well, if the adjuster knows what the legal position is of that particular body part or that particular treatment or that doctor, right? The history with that doctor, them having the ability to be the level 1 reviewer will cut out the risk that it's being authorized for something and waiving defenses. Absolutely. And so that's a great recommendation. I totally agree with that. The second thing you mentioned was the having a system where different people within the system believe that once you have the established body part, all of the treatment to that body part forever is linked. And I always think back to when I first started doing workers' compensation, and you litigate these variance denials, and you'd have actual judges and claimants' attorneys go, the knee's established, there's a tear, I get this surgery. That's what the guideline says. And it's actually not true. So you're just basically assuming that everybody that has a tear got it just because of a timeline correlation, right? So everybody with a pre-existing tear, you're actually convincing them and encouraging them to file workers' compensation claims because this tear is going to be taken care of. And I do think that it is a risk with the PAR system, the onboard system, because if they're only determining medical necessity, right? Yeah. And they don't have the information on whether or not it was pre-existing, they don't have a prior claims report or a medical canvas, or they don't know what we know about the case, they're going to see that, right? They're going to see knee established, tear, arthroscopy. right? Or meniscectomy. And that's a huge problem that we face. I think the third thing you mentioned, I might have already forgotten it because I already went into the tangent of the first two. The third thing you mentioned was
the RFA too.
The RFA, yes, perfect.
Against future treatment, yes.
Yes, okay, now our listeners know that we definitely didn't workshop this before recording, which is also good for organic conversation. So yes, the RFA2 option, because what you have actually is more cases where if the treatment's denied for an unestablished body part, that usually comes in the form of a C8.1B, right? They file the form, and then whether that gets entertained by proposed decision or an actual hearing, it just becomes part of the case, right? We're not thinking about that. But this new RFA2 for a level 3 MDO issue, or even before it gets there, to file a request and say, wait, I want to litigate this to offset the risk that I have in the future of this punishing me. I think, as I talk about it, maybe you are right. Maybe the board did contemplate something that would be beneficial for us. I guess I'm just so jaded that I believe that the board is always doing something to hurt employers.
Well, if you really think about it, it's kind of like this. Due process is important, even in comp. If you look at a lot of board
due process is important, even in comp. Yeah.
Say comp is warp speed. It's high volume. It's tons of claims. It's warp speed. Things go. I mean, especially compared to third party actions, lawsuits. It's just warp speed, and sometimes it's difficult to give the parties due process to litigate all the issues properly. But if you look at board panel decisions, how they handle, I would say the most common issue is if you request cross-examination of a doctor on an issue and it's not granted by the judge, the board panel will almost 100% of the time say you have a due process, you request cross-examination, you're given that right. That opportunity. And I think that was a concession here because of the causal relationship issue, not being allowed to really develop that, not having that due process. I'll put it, give it that put it under a grandiose due process headline. I think that really was a concession to that, because imagine a scenario where the carrier is like banging the table saying, look, the medical necessity, yes, it's there, but we want to fight causal relationship. You got to let us fight causal relationship. There's no box to check.
Right.
Level 2 review saying that the site's established but isn't causally related. It's kind of like, let us fight it out. And so I think that is a kind of a due process.
Okay, yeah. No, that's definitely a quotable. Due process is important even in comp. Well, so we have this onboard system. We talked about the advantages, disadvantages. Any specific things that you would recommend that would make it better for all stakeholders, like even our adversaries?
Well, I would say this. Right now, if you wanted to change, and this is something that's come up in several of my cases, if a carrier files grants a PAR request, they authorize it, level 1, level 2, they cannot go back and change that authorization. They cannot. Now, the only change that can be made is when it was denied. If it was denied,
right.
So partially denied, then they can go back and change it to granting it. But if it was granted and then new information comes up, or they find out, it was a mistake, there was an error, usually because of this, you were fighting on certain other issues, like why are you authorizing it? They can't do it. And so what comes up in those cases is and the thing is, once they authorize it, they can't reopen that PAR request. They're going through that onboarding system. It's like you're given the PAR request from the provider, and then you address it, and then it's done. It's closed, and you can't change authorization to a denial. And so what you have to do then is file correspondence or an RFA2, something of that nature with the board saying, by the way, this was authorized, but it was a mistake, and it's really without prejudice still litigating this issue or that issue or causal relationship or something like that. So I don't know why the board didn't allow that. See, with MG2s, and see, for us, as long as you were still within the time frame of responding, and you had mistakenly filed a MG2G or a C4ALT-G, if you then shortly thereafter filed a denial saying, by the way, it was a mistake, this supersedes the prior filing, that was usually good enough. But in this case, there's no option. So I wish the board would allow that, where within whatever it is, within a few days, it's still open, so that they have that option.
That's actually the reason why I think this has been bad for employers, because you have a system where you're really trying to get more treatment authorized. I think that the system was created in part because they didn't want to have litigation over medical treatment clogging the system. And so they had this crazy timeline where you have to respond in 4 calendar days for all these different treatment requests. And obviously, like you said, it's very hard to keep on top of it when you have many cases on your desk or docket. And I think the process was designed to do that. It was designed to get more treatment authorized. And I feel like your recommendation there to change that process and allow a grant to become a denial, just like a denial is allowed to become a grant, like, is part of the reason why it has been so harmful to employers. But hey, your mouth to God's ears, right? Or to Clarissa Rodriguez, chair of the Workers' Compensation Board, right? Yes, let's make mistaken authorizations be supplemented by correct denials. Of course, I think every employer in our great state of New York would sign on for that.
So, I agree. I think that they do want to help claimants because they're fed up with claimants getting treatment denied and not being able to get treatment that they so richly deserve. But it really can't come at the such expense. Everything is tilted towards the claimant, certainly in workers' comp in New York, but that really shouldn't be at the expense of the carrier's right to properly defend the file. And I think they did also want to do away with, when you had all these MG2s and C4Ls being faxed or emailed, there were procedural defenses involved where, the MG2 wasn't served properly or wasn't served on all parties the same day in the proper manner. It wasn't sent to the right email that was designated by the board. The PAR system, the way it's designed, it does away with all of the procedural defects of the C4Ls and MG2. So it immediately moves past that obstacle for claimants because it's instantaneously proper. The service, the electronic service is proper and it's instantaneous, and then the carrier immediately has to address all the issues. So it does favor. That's another reason it favors the claimants and the providers, because it takes away certain procedural defenses. And we know that sometimes delaying certain treatment, allowing other defenses to come to fruition that we have, preventing the claimant from getting certain benefits will often limit exposure, and then say maybe it triggers a claimant going back to work, or things that are much more beneficial to the carrier. So I think part of the system also is.
Well, yeah, you had a very cogent recommendation for the system itself. My recommended change was more selfish. I just feel like there's too many button clicks to get to a PAR document before I figure out what's going on. But, they say a new version of eCase is coming down the pike pretty soon. Maybe my solution is going to be fixed, because I hate that I'm clicking, 6 or 7 times just to figure out that it's a surgery and not a physical therapy round that's being requested. But I think that's a great point to end. Noah, thanks for joining me today. For everybody that's listening, and especially the client that I'll keep unnamed, that we met with a week ago, that specifically said that they listen to the Third Fridays podcast. Thank you so much. It keeps us really engaged with providing this kind of material to all of our clients and prospects. Still going strong, and much thanks or credit is due to the talent and bright minds of attorneys like Noah Pollack here in our office. So thanks, Noah, for coming on today.
Thank you very much for having me, Christian. I really enjoyed it.
All right. So for all our listeners, this is Christian Cison reminding you to defend from day one.